Court sides with regulators in Mountain Valley permit fight. The Fourth Circuit declined to block a North Carolina water quality permit for the Mountain Valley Southgate project. But the ruling's significance isn't really about one pipeline. It's about what courts will and won't second guess when regulators approve permits for developers with prior violations. The U.S. Court of Appeals for the Fourth Circuit denied a request on June 11th to temporarily halt a water quality certification issued by the North Carolina Department of Environmental Quality, NCDEQ, for the Mountain Valley Pipeline Southgate project. The Southgate project is a proposed extension of the Mountain Valley Pipeline that would connect Virginia and North Carolina. Its footprint has been reduced considerably from the original design, from approximately 75 miles to about 31 miles, with the North Carolina segment now running roughly 5 miles. Environmental groups including Sierra Club, Appalachian Voices, and 7 Directions of Service challenged the state's Section 401 Clean Water Act certification and asked the court to pause construction-related approvals while the broader litigation continues. The court declined. Prior violations did not require permit denial, court found. The core argument from environmental petitioners was that NCDEQ failed to adequately explain why a company with a documented history of environmental violations during construction of the main Mountain Valley Pipeline in Virginia and West Virginia should be trusted to meet water quality requirements on a new project. The Fourth Circuit's answer was not that the prior violations were irrelevant. It was that the agency considered them and still provided a reasoned basis for approval, and that under the deferential standard courts apply to technical agency decisions, that was enough to deny emergency relief. According to the opinion, NCDEQ pointed to several factors supporting future compliance: dedicated environmental inspectors on the project, erosion and sediment control requirements, stormwater management obligations, and the agency's own enforcement authority. The court emphasized that it was not endorsing every aspect of the project or guaranteeing that the permit would survive full judicial review. The underlying challenge to North Carolina's certification remains active. This ruling addressed only the narrow question of whether to halt construction approvals in the meantime. What the ruling signals for permitting fights beyond this pipeline. The broader relevance of the decision is what it says about regulatory deference. Environmental permitting fights for pipelines, transmission lines, carbon capture facilities, renewable energy projects, and industrial developments increasingly turn on whether agencies have adequately considered compliance histories and mitigation measures. The Fourth Circuit's ruling reinforces that agencies retain substantial discretion when making predictive judgments about future compliance, even where applicants carry documented violations from prior projects. Regulators do not have to guarantee future performance. They have to show a reasoned basis for expecting it. The court also rejected a second argument that North Carolina failed to include certain environmental protections directly within the permit text. Petitioners argued that safeguards referenced by agency staff during the review process were never formally incorporated as permit conditions. The court found that the permit appeared to incorporate project plans, supporting documentation, and commitments made during the application process, making it difficult to conclude at this stage that the protections were simply absent. For compliance and regulatory affairs teams tracking infrastructure permitting, the ruling adds to a body of precedent suggesting that courts will continue to give substantial weight to agency expertise when regulators can demonstrate a reasoned basis for their conclusions. The legal bar for halting major infrastructure projects before a case is fully heard remains high. That is true even when the applicant's prior environmental record is contested. You've been listening to Sustainability Soundbites by Environment+Energy leader. For partnership opportunities, please reach out to our team.